Dobar dan. Dok Srbija već 10 godina pokušava da donese sopstveni građanski zakonik, evropski eksperti za privatno pravo kreiraju dokument koji bi uveo jedinstvenu normativu za celu Evropsku uniju. U jeku debate o tome da li bi s obzirom na kulturološke, religijske i tradicijske razlike takav zakon državama trebalo nametnuti ili im ponuditi dokument koji bi im poslužio kao orijentir u kreiranju sopstvenih zakona, a mi razgovaramo sa rukovodiocem studijske grupe za izradu Evropskog građanskog zakonika, profesorom Kristijanom von Barom. On je profesor na Univerzitetu u Osnabriku, predavač i saradnik brojnih univerziteta od Sjedinjenih Američkih Država do Japana i osnivač i direktor Instituta za evropske pravne studije. Dobitnik je prestižne Leibnicove nagrade i brojnih drugih priznanja, dopisni član Britanske akademije i autor oko 360 knjiga i prikaza. U periodu od 2010. do 2014. godine bio je i specijalni savjetnik potpredsednika Evropske komisije, a u stručnim i akademskim krugovima smatra se vodećim arhitektom evropskog privatnog prava. On je ovih dana bio gost Univerziteta u Novom Sadu, gde je na Pravnom fakultetu Univerziteta u Novom Sadu održao nekoliko predavanja doktorantima tog fakulteta. Danas je i naš gost. Herr von Bar, guten Tag. Is it even possible to unify private law in a whole European Union, having in mind all differences regarding history, culture, customs, religion, and so on?
Unification of private law is a very difficult business, and one has to understand what we are talking about. For the time being, we are not talking about one single civil code for the whole of Europe. That would not make any sense, and that is for the time being impossible. But there are very many different levels of unification. The first step, by the way, is to understand where we do already have a uniform system of law, although we simply do not know that due to our different languages and different educations, court systems, and so on. As soon as that research is done, and in that area we are making progress at different speeds in different areas. But as soon as we know what we have, we can ask what should be. The latter question is the simple one. Everybody can answer the question what he or she thinks should be. Very few can answer the question what we have, what is. There is one possibility to harmonize, but harmonize in inverted commas, and that is that we draft texts as references, as frames of reference, as sources of inspiration, which are not binding on anybody. That is very important, which are not binding on anybody, but which everybody can consult if he, she, or it, the legislative organ, so wishes. Then there is a third possibility, and that is the possibility that we write textbooks or handbooks or material on the basis of all the member states' law. Here again, one must understand that the European Union has 28 states, but more jurisdictions, because we have many states with more than one legal order. And in such handbooks you will find a basis to teach students all over the place on the basis of the same evaluation of the existing law. So my dream for the time being is not that we all have an identical law. But my dream is that a German law student can start his studies in Coimbra or in Stockholm for no other reason than the reason that his girlfriend or her boyfriend is living there. And then there is even another chance, and that is the cooperation of courts. That depends, of course, on the quality and on the workload of courts. The latter point in practice, the more important. But we have already now various situations where courts in Europe refer to each other's case law decisions. So you will find British cases in which the German Federal Court is quoted. You will find Portuguese cases where the Italian Corte di Cassazione is cited or quoted. So we are approaching each other on all levels. So we have an enormous chance. The European Union has given us the chance of the renaissance of what earlier generations called the Jus Commune Europeum, a common European private law. That is possible. And whether or not there will be a unification apart from what we have, forgive me, that is not for my generation to decide, perhaps for your generation, but at least not for my generation.
Okay, but you're talking about an idea. Is there any resistance to that idea, and where is that resistance coming from?
Yes, of course, to every new idea there is resistance. There's always opposition, otherwise the idea would be boring. The resistance comes, you cannot identify this resistance by saying it comes from country X or country Z. It comes from different corners in society. It is normally coming from the traditional side of the academic world, sometimes with good reason, because of course there is always this centuries-long tradition, and people are afraid that they lose the knowledge of details. The ability to look into one's books, which you have on your shelves, and there is a case, even though it is 35 years old, and then you repeat that answer of that case. That is one concern. There is another concern, and that is an economic concern, not an intellectual, but an economic. And that would run as follows: if we manage to administer law on a pan-European basis, and then an advocate from Frankfurt could open an office in London, and a London solicitor could open an office in Madrid, and a Spanish lawyer could open, as soon as Serbia joined the European Union, an office in Novi Sad. And I personally believe in competition. I think competition is a good idea. But if you earn your living on a legal system, which in detail nobody else but you knows, then you must be against the opening of legal systems. That is easily understood.
A few days ago, European Court of Justice rules that data protection agreement safe harbor with US invalid. What that means for EU citizens, and will that stop Facebook and other networks transferring EU to America, EU data to America?
As a matter of principle, I think the answer must be yes. Europe is an area of freedom, security, and justice. And the transfer of personal data beyond control is certainly something that is in contradiction with this basic idea of justice. We must be able to control our data. We as citizens must be the sovereigns over our own data. And that is not a question of politics. Politicians might believe that that is a question for them, but it is a question for constitutional law. Because privacy is part of the protection of human dignity. And in the country in which I live, there is only one single purpose for a state, and that is the protection of the dignity of human beings. All the rest, in comparison, does not matter. So privacy is at the heart of European law, of constitutional law, of fundamental rights. And then people will of course say, we cannot prevent that, we can't do anything, that kind of blah, 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 which you hear every day. Now, of course we can stop that. And there is an obvious conflict between the internet and the protection of human rights. And if you ask me as a professor of law, then of course human rights must win.
Now let's talk about Serbian laws and issues in Serbia. You know, Serbia is now an EU candidate, and it's waiting for the first chapters to be opened. In the meantime, we are trying to harmonize our laws with laws of European Union. And my question is, how much time is needed for this process to be completed? And how much time will pass from moment we completed and became the member of EU until those new laws of EU would be fully implemented in every part of our society?
The integration of EU law, properly speaking, i.e. law that has its source in the constitutional organs of the European Union, is a difficult task, but it is technically difficult. It is not emotionally difficult, and I don't see any political problems in that. What you need are well-trained, well-educated lawyers. Then it can be done quickly. That depends a bit on the, how do I describe that, on the national emotions in such a situation. When Estonia became part of the European Union, they had in their Ministry of Justice law students. And they managed to integrate all these EU instruments within, I've forgotten, 2 years or so. So, where there is a will, everything can be done.
At the same time, while we are working on that harmonization of national legislation, we are not able to solve some problems which are, for EU countries' deep history. One of that problem is problem of restitution. If you ask people who claimed confiscated property, this process would not be finished in the near future if you ask them. But if you ask authorities, they would say it's not possible to finish that job because the property had been sold, or it's hard to identify property because of the land management and so on. How this problem had been solved in EU countries, and are those some of those reasons I mentioned just excuses of authorities or real obstacles in process of restitution?
Restitution of appropriated property very often leads to a new appropriation. Yes. That is unavoidable. We know that as private international law lawyers since 150 years. There are famous cases in that area. The most famous example was probably the restitution after the reunification of Germany. That, however, was a very special problem, which you can hardly compare with the problems in this country. Because Germany was split. We were two countries. And our West German constitution was not applicable in the eastern part of our country. So nobody could say that this expropriation in East Germany was an offense of the West German constitution. It simply did not apply there. The only question then was, how do we handle this restitution? It was clear that the property should not stay with the state. It was also clear that there were certain groups in society who should get their properties back. Those who suffered from the Nazis. And then we had a rule that properties or estates which were bigger than 100 hectares should not be returned. That was done for purely political reasons. That had a legal issue in it, because it was an infringement of the principle of equality. You cannot explain in constitutionally valid or human rights valid terms that you give back 99 hectares and not 101. There is no reason for that. So that was made part of the constitution. One will not believe it, that we do not return that. We arranged, however, for the old families to get a realistic chance to buy their former property back. In the year 1990, none of these persons were owners of their old properties, of their old estates. But they had a realistic chance to buy it back. And in our situation, I think that was a very good solution, because only those who are interested in the land, who will fight for the land, who will work there, who will invest there, and who will take the risk of a failure, are those who should get it.
And for the end, in Serbia there is ongoing public debate on a uniform civil code. And as we are talking about the state which never had a strong democratic tradition and which has deeply divided society, that has no agreements on some basic values and some social consensus on some debatable issues such as euthanasia, for example. What do you think, is Serbia ready to create and adopt a uniform civil code?
The answer to that latter question is quite easy. Yes, of course. This is one of the most civilized countries in the middle of a civilized continent. So why shouldn't Serbia be able to do that? And whenever you start a discussion on a civil code, there are pros and cons from each and every side. A civil code is an intellectually ambitious task. What you normally find is that people try to avoid these intellectual problems by opening a political discussion. As I said in the beginning, the question what should be can be answered by nearly anybody. The question what is, what the actual status of the Serbian private law is, that question can only be answered by probably relatively few people in this country. I would argue, but that is a very personal view, it would be an exercise that is intellectually enormously fruitful. because it would first summarize the developments of the last over 100 years. Two, it would force those who think about these texts to reassure themselves in foreign material. That is standard today, that is lex artis. It would bring European law through the back door to Serbia, and that in my perception is a very good start. It is technically a good start. It is emotionally a good start. And a civil code will serve a specific purpose. One of the traditional purposes of a civil code is to unify a country. The French Civil Code crowned the French Revolution. The Austrian Civil Code brought Hungary and Austria together. The Italian Codice Civile crowned the Risorgimento. And there's now a new situation for this country, so that might be a good idea to have a new civil code. And there is a further reason. The most modern private laws, believe it or not, are these days in what we call Eastern Europe, what you think is Middle Europe, it doesn't matter. So the most recent codes are in this area of the world. And if the Serbian community and the Serbian intellectual community were brave enough to start that endeavor, you would perhaps have the most modern civil code in the European Union. And I think people would not think of Serbia to have the most modern civil code in the world. So that is a very interesting challenge.
Thank you for this conversation and thank you for your time. Poštovani gledalci, bio je to profesor Kristijan von Bar. Hvala vam na pažnji i ostanite uz Radio Televiziju Vojvodine.